Welcome back to r/LegalAdvice, where people ask questions, get advice, and we get satisfaction. If you are new to my channel, please don't forget to subscribe to join our amazing community, and without any further ado, let's dive right into the stories. And the first one is titled, Father and Mother Died and a Lawyer is Saying Their Property Joins an HOA After Their Death. Details: state is Connecticut. My father moved into a rural area in 1980, a few years after I was born, and soon came my sister. They stayed there ever since, we grew up, etc. My dad died in 2012 and my mom died in December of 2018. My sister moved away in 2002 to get married, kids, etc. and does not want to be involved in the affair since I am the eldest son and she lives quite far away. Over the years the area was developed and is now more of a suburb. Either way, I take possession of the house through the will, affairs of the estate, etc. Basically total control, nothing to worry about. I get a letter in the mail in February that my parents agreed after their death to sell the house through the trust to the HOA and the property would be up for sale. I find no such documentation and my demand to the lawyer, which is a legit licensed lawyer, is going unanswered to provide the written documentation. I have left a few messages with the admin there, but I'm not putting any effort into it if they are not going to respond. I am not one for sentimental value and I really am not attached to the house, so if they want it, the price is going to be dictated by me, not them. I live a couple towns away and I have no interest in moving in, my house is bigger, or even thinking about keeping it. My dad was getting senile and might have agreed to something, my mom is a pushover and might have agreed to something. If it isn't in writing, does it mean it is useless? What if they do come after for the sale? Should I just ask for top dollar and or fight it, making it a non-HOA house in an ocean of HOA property? Edit: after receiving my green slip back and leaving multiple voicemails, I finally got a letter in the mail, but it was basically saying it was a verbal agreement, not gonna fly, good luck. I am sending a letter today demanding an in-face meeting on the property with the lawyer. HOA members or I will be asking the Board of Zoning to change it so I can install a wastewater treatment facility. And a user in the comments said, yeah, I mean, I'm no lawyer, but if it is not in writing, good luck to the HOA. That being said, it sounds like you want to sell it anyway, so yeah, of course, ask top dollar for it. And another user suggested, send a certified letter to the HOA and the lawyer demanding to see documentation. Unless they paid your parents a consideration, any agreement is probably unenforceable. And another person agreed, this: get the name of who at the HOA you can serve papers to and have your attorney ask for the documents for the mysterious deal with a time limit 2 weeks, 30 days. That way they either have to as a real deal of signed contracts or they don't and you can move on and properly sell this property for top dollar on the open market. And another user said, I agree with others here, if there's no writing and no consideration, a payment, then there's no claim. They need to prove it. Having said that though, please check to see if there is a lien on the property put on by anyone. And by the way guys, just on a side note, because this really bugs me, today I checked again on the Merriam-Webster Internet Dictionary how lien is pronounced. And the two ways apparently to pronounce it correctly are lien or lien. Anyway, if there is a lien, you need to get a lawyer and get in front of that and have that lien removed ASAP. Good luck and keep us updated. As someone else said, a non-HOA home within an HOA neighborhood is extremely valuable. Update to the father and mother died story. So, after receiving a certified letter at the end of April from the HOA's attorney, he basically ignored me about the verbal agreement details. I contacted my corporate attorney, who I have known for nearly 2 decades with, and he's got a CT bar license, so he will help if I need to. After not hearing from their attorney for over a couple of weeks, leaving calls and messages with his admin, I realized that I was not going to get what I wanted, which was literally to talk to the guy and get the HOA's documentation. So, one last college try at the end of April and nothing still. I got crap to do, and all I got now is a slab and some overgrown lawn, which with the coming of spring and the constant rain is turning into a mud pit. I live 2 towns over and I don't have time for this. On May 3rd, I sent a notice to the surrounding houses that construction was to begin on a new sewage treatment plant and to contact the HOA board for more information, knowing it would take USPS a day or 2. Brought the dozer back on a flatbed and planted it in the driveway where you couldn't miss it. 8 AM on Tuesday the next week, I got a call from an HOA representative wanting to argue with me in regards to this new plant and so forth about property rights, ownership, etc. Not going to lie, choice words and yelling ensued, ending with, "If your goddamn lawyer would call me back, we wouldn't be having this discussion. Good luck with the smell." Keep in mind, nothing filed with the town, no real desire to create a sewage treatment plant, but if you want to ignore me, good luck. About 45 minutes later, I get a call on my cell phone from an attorney, and I swear to God I was talking to a hostage instead of a lawyer. I told him I will see him at my parents' address at 3 PM and we will finish this deal one way or another and bring a laptop. Wanted to argue about not officially meeting in an office blah blah, and I hung up. That was on May the 7th. I knew full well why I chose to send the letter on the 3rd, that because on Wednesday coming up, the HOA board has its monthly meeting, so I wanted it on the agenda. For about an hour, calls would come in from the attorney's admin wanting to change it to his offices, wanted to work this out by mail, etc. Nope, 3 PM on site. Called my attorney, he luckily was out of court by 11 and would come down, had lunch with him and headed back to the property. I grabbed a couple of lawn chairs, a folding table from my house, and my attorney brought a laptop and a printer. If you know my attorney, I have known him for decades, and he is a no BS, let's get it done, no mercy kind of guy, right from law school. Went from corporate IP to family law and dabbles in real estate, good guy to know. 2:55 rolls around and they show up. The lawyer and 2 board members. One who looks like he should move to God's waiting room and the other a mid-50s kind of guy who is probably an orthodontist. We all make introductions and sit, and I say, this is how this is gonna go. You want this property and I want to sell. I'm tired of the games and the non-responsiveness. In the next 15 minutes you're going to buy this property pending approval, the HOA board majority, and you can do whatever you want with this place. You will own it free and clear. The orthodontist speaks and attempts to say, "As conveyed to us by past board members that your father advised us that the property would automatically be transferred to the HOA upon your parents' death." He actually sounded articulate and with some authority. I like him. Me, what documents do you have to support that? Orthodontist, "Nothing, just witnesses." Goes into a discussion on how it was told to them by board members and that their unresponsiveness was because they thought they were in the clear and no reason to work with me because it was all legal, etc. And that they were going to get the property by some court decree shortly. I look over to my attorney and he looks back. Well, fortunately for you, that is at least 50% true. You will get this property, but it is not free. Brass tacks, you pay all closing costs and you will have my signature the minute you have approval. We will facilitate the documents and the routing wire information. The eyes of the crypt keeper and the ortho went wide and he said, "That's a lot of money. We will have to bring it to the board to vote, but I'm unsure." Good enough for me, we have some preliminary documents and an official letter to present. Looked over at my attorney and was printing the docs away on the table. The lawyer says, "Well, it will take up to 30 days and the bank check will take as long for an entity of this type if this is approved." My attorney then says the best thing I heard in a long time, love you Mark, "We have e-file capability with 3-day turnaround filing to the state. Towns and wire transfers take no more than 15 minutes unless the feds are backed up. There's no title issue, no liens, no environmental or waste removal issues. It is yours to enjoy as you see fit. I will be available right after the HOA meeting to file the documents and Tuesday to receive the transfer." That's why he gets paid. He hands over the docs, standard P&S with the amount just typed in, with our cover letter for the board. I grabbed the ortho's business card. Apparently he is a school admin, the other guy is a retired electrician, and the attorneys as well. Well, the board meeting went well. I was told by a resident that it was a lot of arguing about not having documentation, wanting to actually challenge my ownership of the estate/property in court, and eventually the amount. Yeah, I asked a lot, but then again they could have countered and didn't. It was not a good meeting, but in the end it was approved. Apparently another lawyer who was a resident basically told them they had no standing and I could do whatever I want with it, with or without the board's approval. I don't know if the HOA lawyer was there. My lawyer dropped by 10:15 p.m. at a pub 99 and I signed the docs for the final P&S and we had beers as he filed online. He said I would get a copy in a week and would file paper copies with the town, but the deal is done when the money is transferred. Today, 8:15 a.m., I got a message that the HOA initiated a wire transfer and around 8:45 a.m. got confirmation of receipt of funds. My parents bought the place in December 1980 for $28,500. It served us well and I flipped it for nearly 27 times that. It was a good home, but you have to move on. It will be built or turned into a park or something, but alas, it is over and done with. Most of it is going to my kids' college and technical school tuition and the rest to my sister for her kids. Thanks, Dad. And really guys, at first I thought that this was gonna be more of a sad story given the title, but in the end it was really satisfying to read if you ask me. In addition guys, if you enjoy my daily content, please don't forget to like the video and post some star emojis in the comments. This would help my channel tremendously. Thank you so much in advance. And now let's move on to the next story. And the next one is titled, "My roommate has knowingly prevented me from living the last 3 months of my lease by getting a cat illegally against contract. I am severely allergic. I feel that she needs to compensate me for these 3 months worth of rent, but what if she refuses? Do I have any legal basis to sue?" So I'm not really sure what to do here. I'm still paying on the lease on a private BD/BA in 4-bedroom apartment, despite not regularly living there since March. I did not officially move out, much of my stuff is still there, but I've only been there a handful of times since the quarantine. The thing is, the apartment itself is a pet-free unit, and furthermore, I have a severe anaphylaxis level allergy to cats. All of my roommates were well aware of this. However, one of my roommates had her birthday at the end of April and got a cat which she hides from the landlord. She did not tell her other roommates, who are still living there, beforehand, and she only finally told me about it last week. While I wasn't happy about it, I was like, whatever, since I was not regularly living there. Last week though, I realized that I needed to get my summer clothes from my apartment as it is getting hot and I only had my fall clothes at my parents' house. I took an allergy pill and went to the apartment. I was only there for 15 minutes, not touching anything except stuff in my locked room, and I still had a massive allergy attack. I had to use my emergency inhaler and everything. The attack lasted for 2 hours and nearly put me in the hospital. She didn't tell me about the cat for 2 weeks after getting it, so if I had gone there unknowingly and without taking allergy medicine beforehand, she could have legitimately killed me. I don't carry EpiPen since being in an enclosed space with a cat is usually a very easy situation to avoid. I ask everybody about it before going to their house or moving in with them, etc., and my doctor does not recommend it for this purpose. I am now pretty upset since she has effectively blocked me off my apartment, which I am still paying for until the end of July with her illegal cat. I had plans to still go there sometimes to get away from my parents or to use the amenities, pool, gym, etc., but now I basically can't. I would have at least liked the option. When I asked her if she could have waited to adopt the cat until June, she moves out the first, she got upset with me and said that the cat has helped her through the quarantine. Even after she moves out, I still would not be able to go over there because of lingering cat hair/dander, even if deep cleaned. I've gotten sick from being in houses that haven't had cats in years. I talked to my leasing office, and due to little things in the lease contract, apparently they cannot let me out of my lease, and all they can do is give her a lease violation and offer me the option of moving to another 4-bedroom apartment in the property. I would rather be compensated for the loss of my apartment and not be moved to a random new unit with random people I don't know for the last few months of my lease, and I have requirements such as they must be all female, must be on the first floor, I am handicapped, and must not have cats, so I'm not even sure if a match could be found that fits this criteria. I want to ask her for the $1,500 worth of rent, but if she refuses to compensate me, would I have any legal basis to sue her for it? Would it even be worth it for such an amount? Here's an update since this morning. The landlord called me this morning and gave me some options. She sent the roommate a lease violation with a fine and an order to remove the cat within 48 hours and to deep clean the apartment. The landlord will not let me out of my lease since it can be reasonably amended instead by putting me in another 4-bedroom apartment with random people I don't know, but oh well, if they can find one. I would rather get out of my lease altogether, but it may not be possible. This is in Texas. And a user in the comments said, lawyer here, let's say you actually did take the landlord to court, they would claim that the first notice they received of the issue was when you went to the leasing office just recently. Though your roommate may be causing a nuisance and/or breaching the lease, they have a reasonable period of time after notice to correct the issue. So your claim against the landlord is rather small, if even anything. Now let's say you actually take the roommate to court, similar problem. Despite your awareness of your own allergy, you state, I was like whatever since I wasn't regularly living there. This implies that you took no substantive action against the roommate to express how this made the unit uninhabitable for you. I would like to see the terms of the lease and the lease execution framework, 2-tenant or 2-contract with each tenant, but based on the limited information you provided, you likely don't have much in the way of damages due to your delayed raising of the issue. The leasing office made you a generous offer that they likely had no legal obligation to extend. I would take it. And guys, if you were in OP's situation and you had such a massive cat allergy, what would you have done in this situation? Let us know in the comments. And the last one is an update to the story, actually posted on a different subreddit, so I definitely had to do a little bit of digging. I called the landlord and told them all about it. They said they will make it look as if maintenance discovered the cat and reported that way. She will get a fat $500 fine and have to get rid of the cat within 3 days. If I cannot get out of my lease, she may have to pay me the $1,500 worth of rent she has prevented me from using, $500 per month times 3 months. She may also have to pay to have the apartment deep cleaned. This looks like a win for me. And guys, unfortunately, we have already reached the end of the video. I hope you enjoyed today's stories, and if you haven't already, please also go to patreon.com/ripeyoutube, where I upload exclusive Reddit videos starting at just $3 a month. This is a great way to support me in case you are interested, and the chance for me to become independent from YouTube revenue. Thank you so much for watching. Please don't forget to subscribe and like the video, and I hope to see you again tomorrow.